like candles in the sun. I'm not a fan of gun violence, nor having a strap, but get popped once, and I swear that you'll be scrambling for one. But our plans was to get funds and skate off the set, so I mixed the kush with the dro to make all my weight stretch. I'm from with a dudes rob and argue all day about who's the best MC, Saha Stacks and T.I. while dodging the GBI. My bad, I love GZI, but I'm still the best to ever do it, and I ain't even put a CD out. So the next time you say that I ain't got no lyricists, I just think you ain't got a taste for this exquisite shit. My verses are like Leviticus to the underprivileged. I make music for the world, you make music for a stripper bitch. Nick Black leather, beret cap era, guns at your capital, take it to that measure. It's Huey, nigga. It's Huey, nigga. Never been a victim, a rebel against the system. Lames wanna diss them and women just wanna kiss them. It's Huey, nigga. It's Huey, nigga. It's that God flow. What they nailed Jesus to the cross for. And he came back 3 days after he died flow. This Pablo. Talking to kids in Chicago. Mob flow. This that midget New Jersey drive flow. Side note, I wrote this rap with my eyes closed. Bravo. Cause it came out clean as the Moss flow. Costco. Hoes selling they twat for a condo. Benny Hunters and Roscoe. Picasso. Knives mixed with a pop flow. Rappers can't stand me. This that Grammy knife flow. Let me stop though, cause I'm going digital with the syllables. Saha the Prince and I'm royalty like residual. These hoes for me, they supposed to be hospitable. When they in the house with a nigga that's not typical, this not fictional. I run this bitch like elliptical. Can another rapper come out of Atlanta if he not lyrical? Nigga, black leather, beret cap era, guns at your capital, take it to that measure. It's Huey, nigga. It's Huey, nigga. Never been a victim, a rebel against the system. Lames wanna diss them and women just wanna kiss them. It's Huey, nigga. It's Huey, nigga.
This that shot right, where out of towners die at. I advise you book your flight now and fly back. Gangland, bang then, what you claim, fam? Box Chevys, foreigns, buck 50 flow. Young nigga got bitches at the 50 though. 50 pack done, good, drop off 50 more. My city rough, but I made it in it. Trap house look like it's what K's invented. Trust nobody, even friends, look, I hate up in it. Rhyme dirty with your bitch smoking, wait a minute. LA garage with Illinois and Decatur in it. Nigga snitching, I'm like, way to win it. Nigga looking like a state defendant. Four dollar like a two though. My $2 like a full though. I'm cutting up, call me Zorro. Hit him in his mask, get him a body bag. Give me a track, and I'ma body that.
Good afternoon to everybody out there, man. Tune into the YouTube streets already. You're on Facebook. Please like the stream, share the stream, tell a friend that we're live on Kofi Pie Side TV, and you're with your brother Sean P in the place to be. We'll be joined by others lately. Roe versus Wade was handed down a few hours ago, and everybody is going nuts, insane, crazy, out the blue. What does this mean for Black people, Black women in general, right? Because this was like a pro-choice thing, right? And for some people, they feel like it was a slap in the face, and and their choice to decide what to do with their bodies has been revoked. And you have again the strong presence of a women's movement that's being handed down to us going on. That's gonna lead some things astray. So I want to get right to it, man, and just thank everybody for tapping in, tuning in. Those of you who like or dislike, whatever the case may be, give us a reaction. Whether you like me or don't like me, this is the place to be on this afternoon, dealing with Roe versus Wade, a woman's right to choose or not to choose. So I don't expect a lot of people to really get involved in this, because from a male's perspective, you know, we in the way. You know what I mean? Like, this is purely a woman's women's fight. However, we have to bag the sisters up on however they feeling about whatever the case may be. You know, we have sisters out there that are pro something and then not pro. You know, they go against those things. So we have to stay in the middle of the arguments. But what type of effect will this have on the Black community? You know what I mean? Will this take us to an era of illegal birth control methods or underground birth control methods and things of that nature? Right? We seen people gearing up for this when they got ready to take Margaret Sanger or whatever off the statue down or whatever the case may be. We saw remnants of that, right? So let's just get straight into it for those of you who are not really too familiar with Roe versus Wade. And for those of you who will catch the replay, of course, I always source up. My sources are always be in the description of the video. And as people probably trickle in a little bit later, I just want to go over Law Information Institute, open access to law since '92 from Cornell Law School. A magnificent source is pretty much going to sum up a little bit here. And I'm not going to get into all the details because as you can see, this exchange is fairly long now. It's condensed in a sense, but it's a lot of technical stuff that's going on here. And this website is a good website for you to be able to pull out the law dictionary, look at these different, you know what I'm saying, sources right here for you to be able to deal with it. So the Supreme Court ruled back in the 70s, right, in this situation for people that are unfamiliar with it. Okay, so Roe versus Wade was argued December 13th, 1971, re-argued October 11th, 1972, decided January 22nd, 1973, rehearing denied in February 26, 1973. And lo and behold, you can mark down June 24th, 2022, when they get ready to start updating all of this. So they should give us a new rehearing date and a deciding date for Roe versus Wade. So 2 new inserted dates should be updated within this presence. Now, man, here's what took. We'll look at the syllabus, and as I stated, we'll take a look at a few of these things and not everything in particular. It's sad that not a lot of people are tapped into this, but it's okay. We're gonna get it cracking. Anyways, maybe somebody else is live and they're arguing whatever they're arguing. I don't know. But a pregnant single woman, Roe, brought a class action challenging the constitutionality of the Texas criminal abortion laws, which proscribe procuring or attempting an abortion except and medical advice for the purpose of saving a mother's life. A licensed physician, Halford, who had 2 state abortion prosecutions pending against him, was permitted to intervene. A childless married couple, the Does, the wife not being pregnant, separately attacked the laws, based alleged injury on the future possibilities of contraceptive failure, pregnancy, and unpreparedness for parenthood, and impairment of his wife's health. A 3-judge district court, which consolidated the actions, held that Roe and Halford and members of their classes had standing to sue and presented justably controversies, ruling the declaratory, though not injunctive relief was warranted. The court declared abortion status void as vague and overbroadly infringing those plaintiffs' 9th and 14th Amendment rights. The court ruled the Doe's complaint not justable. Appellants directly appealed to the courts on the injunctive ruling and appealed across appeal from the district court's grant of declaratory relief to Roe and Halford held. So just get into a couple of these. While the 28 U.S.C. 1253 authorizes no direct appeal to the court from the grant or denial of the declaratory relief alone, review was not foreclosed when the case is prepared before the court on appeal from specific denial or injunctive relief and the arguments as to both injunctive and declaratory relief are necessarily identical. P. 123. Roe has standing to sue. The Does and Halford do not. Contrary to appellee's contention, the natural termination of Roe's pregnancy did not moot her suit. Litigations involving pregnancy which is capable of repetition, yet evading review, is an exception to the usual federal rule that an actual controversy must exist at review stages and not simply when the action is initiated. So there's several pages of this back and forth and declaratory statements that are being made, and they're documented over and over and over and over and over and over and over till you get way down here. Now, I'm coming down here for a particular reason. And it goes, this is the reason. Jurisdictions have it enacted in abortion laws prior to the adoption of the 14th Amendment in 1868. You had Alabama, Arizona, Arkansas, California, Colorado, Connecticut, Florida, Georgia, Hawaii, Idaho, Illinois, Indiana, Iowa, Kansas, Louisiana, Maine, Maryland, Massachusetts, Michigan, Minnesota, Mississippi, Missouri, Montana, Nevada, New Hampshire, New Jersey, New York, Ohio, Oregon, Pennsylvania, Texas, Vermont, Virginia, Washington, West Virginia, Wisconsin, 36 states. Abortion laws in effect in 1868 and still applicable as of August 1970, same states, but a little bit shorter. So there will be 21, right? So boom. Let's dig a little bit deeper into Roe versus Wade from a Planned Parenthood perspective. And I apologize for not putting it on the screen a little bit bigger, but maybe this will be a little bit better for your eyes. So Roe versus Wade is history and impact, right? So let's get into some specifics. So on January 27, 1973, the U.S. Supreme Court announces a decision, a challenge to the state statute that made it crime to perform an abortion unless a woman's life was at stake. The case had been filed by Jane Roe, an unmarried woman who wanted to safely and legally end her pregnancy. Side with Roe, the court struck down the Texas law. In its ruling, the court recognized for the first time that the constitutional right to privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. This is the significance of today. Roe has come to be known as the case that legalized abortion nationwide. At the time the decision was handed down, nearly all states outlawed abortion except to save a woman's life or for limited reasons such as preserving the woman's health or instances of rape, incest, or fetal anomaly. Now, Roe rendered these laws unconstitutional, making abortion services vastly safer and more accessible to women throughout the country. The decision also set a legal precedent that affected more than 30 subsequent Supreme Court cases involving restrictions on access to abortions. Oh yeah, peace, by the way, for those people tapping in. Now, ruling reflects American traditions, changing times. To reach its decision in Roe, the Supreme Court drew on decades of case law that established that the government cannot interfere with certain personal decisions about procreation, marriage, and other aspects of family life. In Griswold v. Connecticut in 1965, an appeal of the criminal conviction of the executive director of Planned Parenthood League of Connecticut for providing contraceptives to married couples, the Supreme Court found that a state statute making it a crime to use birth control violated married couples' right to privacy. 7 years later, the justices found that this right also applied to single people. Eisendat versus Baird in 1972. Together, these cases set the stage for Roe. Roe was also a reflection of changing times. By the late 60s, a nationwide effort was underway to reform the criminal abortion laws in effect in nearly every state. Healthcare providers, women rights advocates, clergy members, and legal community lobby state legislators and went to court to overturn statutes that had been in place since before the turn of the century. Many of these laws dated back to the mid-1800s, when state legislators moved to ban abortion despite the nation's history since colonial times of allowing abortion prior to quickening. Between 67 and 73, 4 states, Alaska, Hawaii, New York, and Washington, repealed their abortion bans, while 13 other enacted limited reforms. Even before Roe was decided, lawsuits challenging criminal abortion laws had begun to work their way through courts in more than a dozen states. A constitutional right is defined. So in Roe, the Supreme Court found that a woman's right to make her own decision about her pregnancy deserves the highest level of constitutional protection. The court also recognized that the right to privacy is not absolute, and that the state has valid interest in safeguarding maternal health and protecting potential life. A state may, but is not required to, prohibit abortion after viability, except when it is necessary to protect a woman's life. What up, Pure? In 65, we're in 2022. In 1965, abortion was so unsafe that 17% of all deaths due to pregnancy and childbirth were the result of illegal abortion. Today, less than 0.3% of the women undergoing legal abortion at all gestational ages sustain a serious complication requiring hospitalization. Among women undergoing legal first trimester abortion procedures, the percentage sustaining serious complications dropped to 0.05%. The risk of death associated with abortion increases the length of pregnancy from 1 death to every 1 million vacuum aspiration abortions at 8 or fewer weeks to 8.9 deaths after 20 weeks gestation. So in 2007, the maternal mortality rate in the US was 12.7 deaths per 100,000 live births. A significant difference in maternal mortality rates between ending a pregnancy by abortion and carrying it to term. That's math many people didn't even thought existed. The risk of death for medication abortion through 63 days gestation is about 1 per 100,000 procedures. In comparison, the risk of death from miscarriage is about 1 per 100,000. And the risk of death associated with childbirth is about 14 times as high as that association with abortion. The ability to make this personal health care decision has also enabled women to pursue educational and employment opportunities that were often unthinkable prior to Roe. The Supreme Court noted in 92 that their ability to control their reproductive lives. Justice Harry Blackmun, the author of Roe, called the decision a step that had to be taken as we go down the road toward the full emancipation of women. So, there was constant attacks under the right to choose abortion. We all should be very much aware of the decisions that are made within these times. Men not wanting to abort or women not wanting to abort, and circumstances being the ultimate decider for a lot of people. And I say circumstances very loosely, but generally, because, we don't know what circumstance led to the pregnancy to begin with, right? You got people out there claiming trap babies, all of these things in the neighborhood, so on and so forth. But I don't want to get into that now. Immediately after Roe was decided, opponents on safe and legal abortion urged state and federal lawmakers to pass laws stripping away at or abandoning abortion. Oh my goodness. I knew we was gonna get a couple of deals today. Abortion, demonic. Well, over here on this channel, the devil doesn't exist. So you're gonna have to try that again somewhere else. But we appreciate you tapping in. Now, over the next 3 decades, the Supreme Court was repeatedly called upon to decide whether a wide range of abortion statutes violate a woman's rights to its privacy. While many of these restrictions were found unconstitutional, the court opened the door to limits on the ability of low-income women and young women to make decisions to end a pregnancy in a series of cases beginning in the mid-1970s. State and federal bans on funding for abortions were upheld as requirements that young women obtain the consent of or notify their parents prior to abortion. 2 examples of these restrictions decisions are Harris versus McCray, Hodgson versus Minnesota. By 92, changes in the makeup of the Supreme Court led to a belief that it might overturn Roe and it decided to challenge to several Pennsylvania abortion restrictions. However, in Planned Parenthood Southeastern Pennsylvania versus Casey in 92, the court reaffirmed the core holding of Roe, that the constitutionally protected right to privacy includes every woman's rights to make her own personal medical decisions. Nevertheless, the court made it difficult for women to succeed in challenging laws that were less than absolute prohibitions on abortion. The court ruled that in order to succeed in the constitutional challenge, a law must be shown to have the purpose or effect of placing a substantial obstacle in the path of women seeking an abortion. Under this test, many abortion restrictions have been upheld, including requirements that women make multiple trips to an abortion provider and suffer an enforced delay prior to obtaining an abortion. I'm going to sum it right here. In 2007, additional changes in the makeup of the court led to further restrictions on women's ability to make personal decisions about their pregnancy. Despite having struck down a similar law just 7 years earlier in Stingberg versus Cohart in April 2007, Gonzalez, Cohart, Gonzalez, and Planned Parenthood, the newly composed court in a 5-4 decision upheld the first federal legislation to criminalize abortion. This legislation, the so-called Partial Birth Abortion Ban Act of 2003, which does not contain an exception for women's health, makes it a federal crime to take certain steps when performing a second trimester abortion. In upholding the ban, the court effectively overruled a key component of Roe that it had previously affirmed again and again, that women's health must be the paramount concern in laws that restrict abortion access. Retreating from this core principle, the Supreme Court allowed Congress to ban certain second trimester abortion procedures that doctors and major medical organizations, including American College of Obstetricians and Gynecologists, believe are sometimes the safest and best to protect women's health. As Justice Ruth Bader Ginsburg explained in the dissent in Cohart, while the court did not directly overrule any of the precedent, the decision is alarming because for the first time since Roe, the court blessed a prohibition with no exception safeguarding a woman's health. So there's a gang of sources that actually end up right there, but I'm going to read the last part. Moreover, in Cohart, the court took a very expansive approach toward the state interest that may justify abortion restrictions. The implications of the court's decision in Cohart remain to be seen. Yeah. So I want to take a trip to Mississippi. You know what I'm saying? We got our boy Kofi. You know, he Mississippi. So I went to Mississippi for this October term 2021. And then in this appeal, the Supreme Court of the United States syllabus, you had Dobbs, State Health Officer of the Mississippi Department of Health, ETL, Jackson's Women Health Organization, right? You have the criteria to the United States Court of Appeals for the Fifth Circuit. Doc number 19-1392, argued December 1st, 2021. It was decided June 24, 2022. Mississippi's Gestational Age Act provides that except in a medical emergency or in the case of severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. Down here in the state of Mississippi, this is what this is arguing. Respondents, Jackson's Women's Health Organization, an abortion clinic, and one of its doctors challenged the act in federal district court, alleging that it violated this court's precedents establishing the constitutional right to abortion, in particular Roe v. Wade and Planned Parenthood of Southeastern Pennsylvania, KC. The district court granted summary judgment in favor of respondents and permanently enjoined enforcement of the act, reasoning that Mississippi's 15-week restriction on abortion violates the court's cases forbidding states to ban abortion pre-viability. The Fifth Circuit affirmed. Before this court, petitioners defend the act on the grounds that Roe and Casey were wrongly decided and that the act is constitutional because it satisfies rational basis review. Held. The Constitution does not confer a right to abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives. The critical question is whether the Constitution, properly understood, confers a right to obtain an abortion. Casey's controlling opinion skipped over that question and reaffirmed Roe solely on the basis of stare decisis. A proper application of stare decisis, however, requires an assessment of strength of the grounds on which Roe was based. The court therefore turns to the question that Casey plurality did not consider. I know I'm going over a lot of people's heads, but you have to know what's going on around you before you can even get into the realm of identifying all the issues that may come behind this or all the things that may prosper from this. First, the court reviews the standard that the court's cases have used to determine whether the 14th Amendment reference to liberty protects a particular right. The Constitution makes no express reference to a right to obtain an abortion, but several constitutional provisions have been offered as potential homes for an implicit constitutional right. Implicit. Roe held that the abortion right is part of rights to privacy that springs from the First, Fourth, Fifth, Ninth, and 14th Amendments. The Casey court grounded its decision solely on the theory that the right to obtain an abortion is part of the liberty protected by the 14th Amendment's due process clause. Others have suggested that support can be found in the 14th Amendment's equal protection clause, but that theory is squarely foreclosed by the court's precedents, which establishes that a state's regulation of abortion is not a sex-based classification and is thus not subject to the heightened scrutiny that applies to such classifications. You can see Gildadig versus Alejo, Bray versus Alexander Health Clinic. Rather, regulations, prohibitions of abortion are governed by the same standard of review as others' health and safety measures. So next, the court examines whether the right to obtain an abortion is rooted in the nation's history and tradition and whether it is an essential component of ordered liberty. The court finds that the right to abortion is not deeply rooted in the nation's history and tradition. The underlying theory on which Casey rested, that the 14th Amendment's due process clause provides substantive as well as procedural protection for liberty, has long been controversial. The court's decision have held that the due process clause protects two categories of substantive rights: those rights guaranteed by the first 8 amendments to the Constitution and those rights deemed fundamental that are not mentioned anywhere in the Constitution. In deciding whether a right falls into either of these categories, the question is whether the right is deeply rooted in our history and tradition, and whether it is essential to the nation's scheme of ordered liberty. Thames versus Indiana. Internal quotation marks, as you can see. The term liberty alone provides little guidance. Thus, historical inquiries are essential whenever the court is asked to recognize a new component of the liberty interest protected by the due process clause. In interpreting what is meant by liberty, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own ardent views about the liberty that Americans should enjoy. For this reason, the court has been reluctant to recognize rights that are not mentioned in the Constitution. Collins versus Hawker Heights, 503 U.S. Doc 115, 125, guided by the history and tradition that map the essential components of the nation's concept of ordered liberty. The court finds the 14th Amendment clearly does not protect the right to an abortion. Until the later part of the 20th century, there was no support in American law for constitutional right to obtain an abortion. No state constitutional provision had recognized such an act. Until a few years before Roe, no federal or state court had recognized such a right, nor had any scholarly treaties. Indeed, abortion had long been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages. American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions. By the time the 14th Amendment was adopted, 3/4 of the states had made abortion a crime at any stage of pregnancy. This consensus endured until the day Roe was decided. Roe either ignored or misstated this history, and Case declined to reconsider Roe's faulty historical analysis. Respondents' argument that this history does not matter flies in the face of a standard court that has applied in determining whether the asserted right that is nowhere mentioned in the Constitution is nevertheless protected by the 14th Amendment. The Solicitor General repeats Roe's claim that it is doubtful abortion was ever firmly established as a common law crime, even with respect to the destructive of quick fetus. But the greatest common law authorities, Bracton, Koch, Hale, and Blackstone, all wrote that a post-quickening abortion was a crime. Moreover, many authorities asserted that even a pre-quickening abortion was unlawful, and that as a result, an abortionist was guilty of murder if the woman died from the attempt. The Solicitor General suggests that the history supports a woman's right because the common law's failure to criminalize abortion before quickening. But the insistence of quickening was not universal. We can see Mills versus Commonwealth, State versus Sagel in North Carolina. And regardless, the fact that many states in the late 18th and 19th century did not criminalize pre-quickening abortion does not mean that anyone thought the states lacked the authority to do so. Instead of seriously pressuring the argument that abortion right itself has deep roots, supporters of Roe and Casey contend that abortion right is an integral part of a broader entrenched right. Roe termed this a right to privacy. Casey described it as a freedom to make intimate and personal choices that are central to personal dignity and autonomy. Ordered liberty sets limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between interests of women who wants an abortion and interests of what they termed potential life. But the people of various states may evaluate those interests differently. The nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. Finally, the court considers whether a right to obtain an abortion is part of a broader entrenched right that is supported by other precedents. The court concludes the right to obtain an abortion cannot be justified as a component of such a right. Attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept of existence prove too much. So Casey, 505, you can see that. Those criteria at a higher level of generality could license fundamental rights to illicit drug use, prostitution, and the like. What sharply distinguished the abortion right from the rights recognized in the cases on which Roe and Casey rely is something that both those decisions acknowledge. Abortion is different because it destroys what Roe termed potential life and what the law challenged in the case calls an unborn human being. None of the other decisions cited by Roe and Casey involved the critical moral questions posed by abortion. And the court's conclusion that the Constitution does not confer such a right does not undermine them in any way. Peace, melanated. What's good? A child can decide to cut their, yep. A woman can decide what they will do with their bodies. I wish this country would make up their mind if they will make laws based off morals. I got you, Ogun. Appreciate that. I'm looking right now, bro. Oh, you mean the chat in here? Yeah, I saw that. Yeah, I seen that. I seen it. Yeah, you know it's a troll all day long. Let's continue. I expected, you know what I mean, because of the title and the hits that people are getting right now. I expected it to be the way. So the doctrine of stare decisis does not counsel continued acceptance of Roe and Casey. Stare decisis plays an important role and protects the interests of those who have taken action in reliance on past decisions. And I'm gonna get into that, melanated. It reduces incentives for challenging settled presidents, saving parties and courts the expenses of endless relitigation. Kimball versus Marvel Entertainment. It contributes to the actual and perceived integrity of the judicial process. Payne versus Tennessee. And it restrains judicial hubris by respecting the judgment of those who grappled with important questions in the past. But stare decisis is not inexorable command, Purser versus Callahan, and is a weakest when the courts interprets the Constitution, Augustani versus Felton. Some of the court's most important constitutional decisions have overruled prior presidents. See Brown versus Board of, yeah, y'all know that. Brown versus Board of Education. Plessy Ferguson, yep. Now, the court cases have identified factors that should be considered in deciding when a president should be overruled. Janus versus State County and municipal employees, the 585 5 factors. Discussed below weigh strongly in favor of overruling Roe versus Wade. So we're going to take a look, and I know that I've said a lot, but we're going to take a look at these 5 factors, right? The 5 factors discussed below weigh strongly in favor of overruling Roe versus Wade. Here is where, and then I'm not going to read all of this, but I want to get to these 5 factors as we're going through this syllabus. And yes, this is 213 pages, and it's Dobbs versus Jackson's Women's Health Organization, and it was just published today. It began and it ended. We got the document right here. So we will take a look at these so-called 5 interests here. The 5 factors discussed below weigh strongly in favor of overruling Roe and Casey. These are the factors, ladies and gentlemen, that people are using to strongly overrule Roe and Casey. We need to know what they are. And then we need to know where our women stand, because I don't mean to say it like this, but every time other women need Black women to get things done, it is in these instances where they try to reach out and pull the Black woman with them alongside and say women and generalize it and make it all women women thing. And I think the history of the womenist movements and the way that Black women were used in some of these instances to help them get what they wanted from men was a little disingenuous. So we have to be very careful and meticulous in understanding what is actually going on. And we can have further conversations at a different time that would actually get involved with that would actually involve expounding on how that whole movement and things of that nature either benefited or didn't benefit the people of our concern. So the nature of the court's error, like the infamous decision is Plessy versus Ferguson, Roe was also egregiously wrong and on a collision course with the Constitution from the day it was decided. Casey perpetuated its errors, calling both sides of national controversy to resolve their debate, but in doing so, Casey necessarily declared a winning side. Those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views. The court short-circuited the democratic process by closing it to large numbers of Americans who disagree with Roe. The quality of reasoning without any grounding in the constitutional text, history, or precedent. Roe imposed an entire country a detailed set of rules for pregnancy divided into trimesters, much like those that one might accept to find in the statute of regulation. See Article 14 of the U.S. Doc 163 to 164. Roe's failure even to note the overwhelming consensus of state laws in effect in 1868 is striking, and what it said about the common law was simply wrong. Then, after surveying history, the opinion spent many paragraphs conducting the sort of fact-finding that might be undertaken by a legislative committee and did not explain why the sources of which is relied shed light on the meaning of the Constitution. As to precedent, citing a broad array of cases, the court found support for a constitutional right of personal privacy. But Roe conflated the right to shield information from disclosure and the right to make and implement important personal decision without governmental interference. See Whelan versus Roe. None of these decisions involved what is distinctive about abortion. Its affected Roe-term potential life. When the court summarized the basis for the scheme it imposed on the country, it asserted that its rules were consistent with, among other things, the relative weights of the respective interests involved and the demands of the profound problems of the present day. These are precisely the sort of considerations that legislative bodies often take into account when they draw lines that accommodate competing interests. The scheme Roe produced looked like legislation, and the court provided the sort of explanation that might be expected from a legislative body. And even more glaring defiancy was Roe's failure to justify the critical distinction it drew between pre and post viability abortions. The arbitrary viability line, which Case termed Roe's central rule, has not found much support among philosophers and ethicists. Now, who have attempted to justify a right to abortion. The most obvious problem with any such argument is the viability has changed over time and is heavily dependent on factors such as medical advances and the availability of quality medical care that have nothing to do with the characteristics of a fetus. This is their points. These are the 5 reasons to overturn Roe. We need to know what the fuck they talking about. Excuse my French, Spanish, and English. When Casey revisited Roe almost 20 years later, it reaffirmed Roe's central holding, but pointedly refrained from endorsing most of its reasoning. The court abandoned any reliance on privacy right and instead grounded the abortion right entirely on the 14th Amendment's due process clause. The controlling opinion criticized and rejected Roe's trimester scheme and substantiated a new and obscure undue burden test. Casey, in short, either refused to reaffirm or reject important aspects of Roe's analysis, failed to remedy glaring deficiencies in Roe's reasoning, endorsed what it termed Roe's central holding while suggesting that a majority might not have thought it was correct, provided no new support for abortion right other than Roe's status as president, and imposed the new test with no firm grounding in constitutional text, history, or precedent. Third, workability. Deciding whether a precedent should be overruled depends in part on whether the rule it imposes is workable. That is, whether it can be understood and applied in a consistent and predictable manner. Casey's undue burden test has scored poorly on the workability scale. The Casey plurality tried to put the meaning into the undue burden test by setting out 3 subsidiary rules, but these rules created their own problems, and the difficulty of applying Casey's new rules surfaced in that very case. Compare 505 U.S. 881 through 87 with 920 to 922. Stevens J. concurring in part of dissenting in part. The experience of the court's appeal provides further evidence that Casey's line between permissible and unconstitutional restrictions has proved to be impossible to draw with precision. Janus 585 U.S. Casey has generated a long list of circuit conflicts. Continued adherence to Casey's unworkable undue burden. Tests would undermine, not advance, the even-handed, predictable, and consistent development of legal principles. Effect on the areas of the law. Roe and Casey have led the distortion of many important but unrelated legal doctrines, and that effect provides further support for overruling those decisions. And the fifth one, reliance interests. Overruling Roe and Casey will not upend concrete reliance interests like those that develop in cases involving property and contract rights. But in Casey, the controlling opinion conceded that traditional reliance interests were not implicated because getting an abortion is generally unplanned activity, and reproductive planning could take virtually immediate account of a sudden restoration of state authority to ban abortions. Instead, the opinion perceived a more intangible form of reliance, namely that people had organized intimate relationships and made choices that defined their views of themselves and their places in society in reliance on the availability of abortion, the event that contraception should fail, and that the ability of women to participate equally in the economic and social life of a nation has been facilitated by their ability to control their reproductive lives. The contending sides, in this case, make impassioned and conflicting arguments about the effects of the abortion rights and the lives of women, as well as the statute of the fetus. The Casey pluralities, speculative attempt to weigh the relative importance of interests of the fetus and the mother represent a departure from the original Constitution proposition that courts do not substitute their social and economical beliefs for the judgment of legislative bodies. The Solicitor General suggests that overruling Roe and Casey would threaten the protective of other rights under the due process. The court emphasizes that this decision concerns the constitutional right to abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. Casey's identified another concern, namely, the danger that public will perceive a decision overruling a controversial watershed decision such as Roe as influenced by political considerations of public opinion. But the court cannot allow its decision to be affected by such extraneous concerns. A president of the court is subject to the usual principles of stare decisis, under which the adherence to precedent is the norm, but not an exonerable command. If the rule were otherwise, erroneous decisions like Plessy would still be the law. The court's job is to interpret the law, apply long-standing principles of stare decisis, and decide this case accordingly. Under the court's precedents, rational basis reviewing the appropriate standard to apply when state abortion regulations undergo constitutional challenge. Given that procuring an abortion is not a fundamental constitutional right. I'm going to say that again. It argues that given that procuring an abortion is not a fundamental constitutional right, it follows that the state may regulate abortion for legitimate reasons, and when such regulations are challenged under the Constitution, courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. Here is their core argument. I'm going to say it one more time. It's in line 5D. 5D. Given that procuring an abortion is not a fundamental constitutional right, it follows that the states may regulate abortion for legitimate reasons. And when such regulations are challenged under the Constitution, courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. That applies even when the laws at issue concern matters of great social significance and moral substance. A law regulating abortion, like other health and welfare laws, is entitled to a strong presumption of validity. Heller versus Doe. It must be sustained if there is a rational basis on which legislation could have thought that it would serve legitimate state interests. Mississippi's Gestational Age Act is supported by the Mississippi legislators' specific findings, which include that the state's asserted interest in protecting the life of the unborn. These legitimate interests provide a rational basis for the Gestational Age Act, and it follows the respondent's constitutional challenge must fail. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. The court overrules those decisions and returns that authority to the people and their elected representatives. Reversed and remanded. Those are the 5 points. I can go further, but I don't have to go further because this gets long. When you get into the specifics, it gets long, really long. So we heard the 5 points. We've read them and we've understood them to be what? So NPR publishes an article today as well at 10:43 a.m., just a few hours ago. You have the future is anti-abortion. Text life to 53445. I am the pro-life generation. Protect conception, protection at conception. Studentsforlife.org. Look on the screen. Where y'all at? This is an anti-abortion activist rally in the Supreme Court on June 6th, 18 days ago. So the decision was made today, and I'm not going to get into the decision. People can actually get into it if you would like. There's a 78 page opinion, and then there's a 30-page appendix. There's a lot of information that we can get into the Supreme Court's ruling of such. But in the instance of what we saw here, there were 5 points that they wanted to get to that seemed to make all the world of a difference for them in these 5 factors discussed below, which weigh strongly in favor of overruling Roe and Casey. Where does that leave our women? I want to go back to something that was made in chat, that was said in the chat by Melanated Goddess. She said, a child can decide to cut their dick off, but a grown woman can decide what they will do with their bodies. So let's talk about that just for a little moment. And I hate to bring this up because this is going to ruffle some of the brothers and sisters that are in the LGBTQ XYZ community. And I'm not trying to deliberately offend any of them, but I'm trying to make it make sense to me that if a child can determine to identify as an opposite sex at a particular age, and a child can decide for the removal of a private part or to add, or enhance something and really not even need their parents' permission on how they properly identify, who are we to decide if a woman has the right to make a decision about something that's going on with her body that may or may not carry, that may carry life? At what level is it life? At what level is it life? And this is something that women have to endure and deal with for quite some time. So who are we? We are the people that will decide to let a child change their identity to identify a certain way in society, but we're going to tell the mother of that child what they can't do. She has a very strong argument and point. And I know we're streaming on Facebook and I know we're streaming on YouTube. So some people may not be able to see certain things. So I'm going to hit the comments. The conscious, let me look at this. The conscience of all those involved in abortion is into ancient Ugaritic underworld pantheon demonism. What? I'm confused. Decentivo says America is sick and dying. Queen Cheetah says shit's crazy. I think, listen, and I agree. This shit's crazy. He who leaves his culture is a slave. Oh my gosh. Okay. You're going a whole nother way. All right. So she says, I say, regardless, I think it's the woman's choice. And for these men to be making these decisions is absurd. Zion says a child will identify themselves with a cartoon character without any personal understanding, no experience of being that character. Facts. So how do they know what they're properly identifying as? Who is anyone to tell someone what to do with their body? The Supreme Court said you better not abort. You lay down, you got it shot up in you, you better have that kid. What you gonna do? A child can decide to block, prevent puberty, but a woman can't prevent child development. They're going to go after contraceptives next. So what do you think that is happening? Because the implications of Roe versus Wade has been significant for quite some time. And Casey, you have to think about it. I gave y'all earlier the date that it actually ran down, right? You know what I'm saying? And people have been trying to claw at it for quite some time. You know, you had these anti-abortion raids and rallies and all of these things, and you have these people, they stand outside these abortion clinics and they walk around in circles. I don't know how the fuck, I don't know how, and I'm finna be very specific, and I hope that I'm not disrespectfully, well, I'm gonna be disrespectful, but I hope I'm not really disrespecting people individually. Generally speaking, how can these women, and y'all know specifically who I'm talking about, pilgrims, some of these pilgrims, I gotta say pilgrims, how can some of these pilgrims Rally outside of damn near every abortion clinic in every city every day. Do you not have a job, or do y'all schedule to rally according to your off days? A group of y'all, and y'all got like a damn group chat, and y'all come up with these little um, anti-abortion uh, rally meetings, destinations, and times. And if it's 4, 5, or 6 of y'all can assemble every day out the week. How are y'all organizing yourselves to spend your freaking off days to do this? And if you're not working, why the hell you ain't got no job, but you got a poster and you walking back and forth with bottled water and a hat on, you sweating, your skin turning cherry red, and you think you're being productive? How? Do you have time for that? So if a woman is raped and gets pregnant, she should have to keep it. She has to keep it? Well, according to the argument, in some instances, an abortion would be justified. In rare instances, like if the fetus is abnormal, there's some health conditions there, something traumatic has to happen that would either prevent your health or the fetus's health. And Melanated answered it, but yeah, she has to keep it if her state is against abortion. Hey, no. Think about it. So, like, all right, keep it a buck, okay? There on in my city, if I go to Hardin Place, and I know where the clinic at, but if I go to Hardin Place, there where the clinic is on a hill that's like literally 2 buildings from McDonald's. So if you go to McDonald's and you go through the drive-through, you can see the clinic on the hill from the drive-through when you're ordering your food. And these pilgrims are out there every day, walking in circles, saying what it is they saying. When one of them get tired, the other ones pick up the slack. That one takes a break, and then they like rotate breaks. They got a whole fucking schedule for this shit. Anna, your 15 minute is at 2:30. Amanda, yours is at 2:45. Casey, yours is at 3. Deborah, yours is at 3:15. Margaret, yours is at 4:30. Ingrid, yours will be at 4:45. Like, they got this shit planned out. Like, it's solid. Like, straight up. And they marching. And they listen. I'm not making this up. This how they be. This how they be right here with the signs and the bullhorn, and it's a body of them. No joke. No joke. When the hell do you got time for that? Now I understand that those are actual students. You know what I'm saying? I don't even get them. Why are you not in class? Why are you not studying? Why aren't you working? Why is you at the Capitol? So let's deal with this. This is a detriment because now you're going to have all these unwanted babies. We already have a effing system for foster care. What do you think is going to happen now? So yes, these unwanted babies are going to fall into the hands of a broken system that is not going to do anything. You also have to think, right, that we also have a system that is set up and designed to increase what some of these kids are going to end up in group homes. Some of these kids are going to end up in juveniles. Some of these kids are going to end up being fostered by parents who may molest them. And we're never going to know these things until later on in these child's lives. Some of these people are going to be always stuck in the system, crackheads, right? They're going to be on heroin, some hard drug, meth. You know, they're not going to be afforded proper education and or opportunities to succeed and win. They're going to be put in extreme circumstances. Some of them are going to be people who don't even respect or care for life anywho. But that's not our decision, is what state representatives are arguing. It's not our decision to decide on that. It's not our decision to get into any of that. That is other people's decision. We have to abide by it, and it is what it is at the end of the day. They are indoctrinated by that. Oh, yeah, that makes sense. So I can't answer what they're really onto. What I actually can answer is that we needed to know what it was that they were using to argue against Roe and Casey and overturn these things. So what I'm gonna try to do is let me see if I can pull up this video real quick. And oh, okay, I see what's going on. Now that I know, I see it now. I see it. I see it now. I see where people are. People are still arguing what they're arguing. So I'm not trying to catch these people live because they've already, you know, done some things. So what I want to do is I want to show y'all something real quick.
To help reduce plastic waste in our environment,
This is my alarm.
The Supreme Court has overruled Roe v. Wade, the 1973 decision giving a nationwide constitutional right to end a pregnancy. The decision is expected to lead to abortion bans or severe restrictions in roughly half the states in just a matter of weeks. The outcome is similar to a leaked draft of the court's opinion that appeared in early May. That was written by Justice Samuel Alito. Alito concluded that Roe and a 1992 case, Planned Parenthood v. Casey, which basically affirmed the right to abortion, were egregiously wrong and needed to be overruled. The case now leaves states free to ban abortion, And as I said, about half the states are expected to do that. And in other states, the right to abortion has actually been expanded in recent months. The court's decision was really the culmination of decades of efforts by abortion opponents to undo the Roe v. Wade ruling. And it was really made possible by the addition of 3 appointees of former President Donald Trump to the Supreme Court. Before that, it would have been unthinkable for the court to take this momentous step. Back at the arguments, Roberts suggested that he might support upholding the law at issue in this case, which is Mississippi's ban on abortion after 15 weeks, without saying anything about the fate of Roe v. Wade. In the end, though, a majority of the court was willing to take that bigger step. There's one abortion clinic in Mississippi, and it doesn't perform abortions after 16 weeks of pregnancy. The Mississippi law, which was enacted in 2018, was really enacted with the intent of challenging Roe v. Wade. It only sought to ban abortions just 1 week earlier than the clinic stops performing them anyway. The strategy was a bit of a long shot at the time because when the law was passed, Justice Anthony Kennedy, who supported abortion rights, still sat on the court, and so did Justice Ruth Bader Ginsburg. Kennedy retired in 2018, Ginsburg died in 2020, and their replacements were both in the majority today to overrule Roe.
So there you have it. Distinctively, that is what transpired. 2 Trump appointees gets you to where we are today. And now Roe v. Wade has been overturned. And what happens next is on the states. So he basically summarized the meaning of me showing you the Mississippi thing. He summarized what Planned Parenthood is expected to see happening in these states. He summarized the significance of Trump appointed justices, and he told you that all of this is because of who you voted for. Where does this leave Black women in 2022 beyond? Yes, I agree. Mitch McConnell is a corporate for some of these things, but I will say this about Mitch McConnell. His state, the state of Kentucky, will do abortions beyond the certain weeks criteria. People from my city, Nashville, everyone in Nashville knew this, would drive to Kentucky if it was after a certain week period and get the abortions performed. We know this. I know this for a fact. My cousin had to take his girl to get it done. We was in college, fresh out of high school, in college. She's pregnant. She going crazy. He playing football. Neither one of them was going to be able to work, just, take care of the kids, whatever the case may be. And it was getting later. She went. He took her. They went. They got her taken care of. You know what I'm saying? They went through the whole thing. So Mitch McConnell's state does those late-term abortions. He should be dealing with that shit. That's where his focus should be. And they ain't too far from the Tennessee-Kentucky state line. Let me get back in here. A man can be a woman, but a woman doesn't have a say with woman's health. That's facts, man. Now, I understand, look, let me say this real quick, and this is no shot at anyone. I understand that there's another conversation that's being had right now, and that seems to be more important than reality. I just bear witness to it. This situation and topic is way more severe than arguing over culture. But it is what it is with our people, and it seems to be where the interest is. And it's sad. However, Ketanji don't even know what a woman is. They got her confused. Yeah. The question was an insult. That's why she paused. Their racism took her aback. Yeah. Yeah. Let me go a little bit further, right? Let me go back. Let me see if I can pull something up for y'all specifically. And get into, let me see what I can do here. Where's that little short? So a little short video I'm looking for. Let me get it to y'all real quick. Share your screen. There we go. Peep this. Oh, you best believe they have the authority to be able to come for some other stuff.
Future of Roe versus Wade. And you've heard us say that a lot this week, Roe v. Wade or Roe versus Wade, but some may not really know what or who these people were. So we want to break that down for you today. ABC 10's Lena Howland is live at the Capitol this morning. Lena, can you tell us about the significance of this case in our country?
Yeah, Bria, good morning. The significance of this case, you know, Roe v. Wade is the name of that original lawsuit which led to the landmark Supreme Court decision all the way back in 1973. And that is what established a woman's right to an abortion in the United States. So let's break that down for you. Roe is short for Jane Roe, and that's actually a pseudonym for a woman named Norma McCorvey. She was 22 years old, unmarried, unemployed, and pregnant for the third time in 1969 when she wanted to have an abortion in 1969. But by the time the Supreme Court ruled in her favor, she had already given birth and put the baby up for adoption. Wade, short for Henry Wade, was the district attorney of Dallas County in Texas at the time, and it was his job to enforce a state law which banned abortions except to save a woman's life, meaning Wade was the person McCorvey sued when she sought the abortion in the first place. But despite that win nearly 50 years ago, UC Davis professor Lisa Aikimoto told us a majority of the Supreme Court does have the ability to go back and decide there is no constitutional right to an abortion.
That means it leaves the issue to the state legislatures and the state governors. So that means in some states, the state legislatures could decide to enact bans or very severe restrictions on access to abortion. But in other states, they might step forward, and several states have already done so, to provide strong protections for the right to decide.
If Roe v. Wade does get reversed, it would not outlaw abortions altogether across the country, but it would be up to each individual state to decide. So if this does move forward, 26 states are either certain or likely to ban abortion, while other Democratic states, such as California, could see an influx of women coming in from out of state seeking care for abortions.
Yeah, Lena, it's really good to know the history when you want to make your own informed opinion on something. So thank you so much for sharing that. On to the future of Roe.
Listen to me. And that's what's going to happen. Some of these more progressive states that will still allow abortions to take place, women will travel to those necessarily qualified states and get them done. It's going to go back to that traveling to get something done. When that threshold has, when you've crossed the threshold of you've identified an actual problem. So what's going to happen is some people are going to be buying plane tickets, going to be gone for a weekend, and then they're going to return back for that weekend. And that's what's going to happen. You heard her say it. People are going to be traveling to California. People are going to be traveling to New York. People are going to travel to these non-Republican influenced states. And for the reemergence of Roe versus Wade, the Supreme Court is going to have to be altered. There's nothing that Joe Biden can actually do. It's a sad day for him as a president because it happened on his watch. But it comes from someone that was appointed before him. Now I'm all for women making their decisions and all of that old stuff. I ain't against that at all. But I know the implications of not aborting. I mean, I've seen it. We living in an era where some of these children didn't even, I don't even want to see it. You see what drugs are doing. What you think heroin is doing right now? These people, these kids that are now doing heroin, they're doing heroin now. Fentanyl. On a weed, on all these hard drugs, meth, all of that. Fentanyl and hard drugs. They're having babies. What the hell do you think is about to transpire about these children from these methamphetamine babies? What do you think about to happen? You seen what crack did to the generation of kids that came out mumble rapping and shit. What you think gonna happen now? Abortion logically is population control. No, it ain't, man. Abortion ain't no damn population control, man. It's not no population control. People that are having abortions ain't thinking shit about no damn population control, man. They're thinking about their life in that moment and what is the implications of what is transpiring. People know their situations. We're not ready to have a kid. We're not going to, and so people are going to be like, well, then you need to put them up for adoption. For what? So the damn child can get 18 years old and find out that they were given up for adoption because their parents didn't have the money to take care of them. Then that's a whole other problem. Then the kid got even more problems. The kid got problems because they were adopted. Then they got more problems because they motherfucking asses is resenting the fact that their biological parents left them to for somebody, with somebody else. That's trauma. That's unnecessary trauma. Have you not seen some of these foster kids? Brainwashed. The fuck I am. I'm furthest from brainwashed. I'm a very rational thinker I live in reality. SK, I live in reality. I've been around these kids, abandoned. I've been around them, went to school with them. My school let all them foster kids come to the schools. I went to school with them. I know what kind of drama and trauma that they actually go through. Not having no one in their corners and being able to do all of these different things. One of my friends on my football team lost his mama, went into foster. His brother fought hard to try to get him up out of there. It just drove him crazy. He was insane. He wasn't right. He couldn't get over the fact. Didn't know his daddy. He was from Memphis. All of that. Great athlete. Dear friend of mine, still to this day. But the trauma, psychologically, he had issues. So his sisters, his oldest sister, fought for the rights of him, finally being able to get them. But before then, he had already experienced this trauma going through high school because his sisters weren't even old enough to be able to get him. And he still didn't have his mama. The black race needs to be on self-mastery, not self-destruction. Aborting a child is not self-destruction. But we do need to be on self-mastery because we need to know what's going on. We have enough kids in the system now, and we have no means of being able to protect them and provide for them a path to be successful. He's asking you a real question because race is a social construct. But look, man, we can talk about this all day. Maybe we should expand a little bit more on it and have an open bill where we can actually get the opinions and views of everyone else and allow them an opportunity to argue their points and get them out. I'm all about leaving the decision up to a woman. If she finds it fit and the situations align themselves and people have a plan in place that will be able to help them handle their situations, the families and everybody participating in involvement, ultimately, and support of that decision, it's all the woman's choice. Now, if a woman brings that choice and sits it in the man lap and they have a conversation about it, and at the end they come to a mutual agreement, then it ultimately is still the woman's choice, but they came to an ultimate agreement that should be respected among the two parties, and they did what was best for their situation, not anyone else's. And it shouldn't be anyone else's business. My own goddamn business. But at the end of the day, we need men to be fathers to their sons. We need women to be mothers to their daughters. And we need fathers to be fathers to their daughters and mothers to be mothers to their sons. For what we got going on right now, we have kids that are killing each other and don't even appreciate life. So you can miss me with all the other stuff. I ain't buying none of that. And we need to be these certain type of thinkers or whatever. If we needed to be all of that, lead by demonstration. Show us the way. Provide a path, a successful solution, and provide. I mean, just render it. Go ahead. Deliver it. So peep game, man. The a syncretism, a means and method of accurately translating Kemet Revised is available. You can go and cop that on the website. It'll give you a link where you can download it and you can read it and you can sink it in and understand it, comprehend it, and the whole 9 yards. It is also up for a peer review process, which we should have a response in less than it's a 2-week process. If it goes up for review or whatever, you know what I'm saying, they're trying to charge me $500 to publish it if it passes the peer review process. However, it is going through the peer review process. So I say all of that to say, people, if you are interested in reading the response, it won't be available to you anytime soon. But only that, no other time. It's not available anywhere else other than where I just put the link at. So if you're interested in reading the response to Brother Reggie's article, it's right there. It's on paper. It's available. And it is all there. You can do that. Pianki said, lay around, learn something. Hey, you know what I'm saying? I don't know if a couple of y'all kind of trickle back in. I don't know if, but I know that I believe somebody else was live. So I figured when I got started that it wouldn't be many people here. And I still think, you know what I'm saying? This is one of those topics that deserve a little bit more attention than what it should get, especially in the community. So maybe more popular people talk about it where people love, you know what I'm saying, that transpires and whatever. So the sources are in the description that was used for this particular bill. Use them wisely. Be mindful of that. Go get that information. Go get that information and handle your business. And then do what you need to do. You find people making videos on YouTube. But I'm gonna let y'all get back to y'all day, man. I'm gonna slide up out of this thing. Yeah, it ain't but $5. People ain't got $5, Chavis. You know what I'm saying? Not for me anyway. They ain't got $5. They might got $5 for, you know what I'm saying, something else. I ain't got no $5 for me, bro. But the article is out. So deal with it how you want to deal with it. It is what it is. At the end of the day, man, we are who we are, and we doing what we need to do.
It's in the place where y'all get a share. Niggas gon' hate, do I look like I care? I was dealing with pain, frustrated with life. How many were there? Thanks to the few for staying true. My oldest to you, it all comes with paying your dues. Some couldn't walk a day in my shoes. Light on my feet, never lie in the ass. You hummingbirds can't say you're bumping them word, I'm way out of your class. Oh, do I shake? I master degrees. Life is a test, every day is a task. For rest of your best, give it all that you have. Move up the block, peel the paint off the ass. Never lose sight of your goals. I made diamonds from doubt. Turn my grief into gold. My destiny was set in stone. They selling ass and selling souls. Hands off a cider, hands off my pocket. You know that chopper, body's probably rock the blocker. All they heard was bow, bow, bow. Sound like Waka Flocka. Straight to the top about it, ain't no doubt about it. Best believe we on the road. No limit, so we body, chiefing on a whole lot of woe. Number one with a bullet, no. Similarly, boost hit the function, we Hennessy. I feel like 96 Tennessee. Yeah, ho, I'm on they head, fo. Always ignoring the sound. Now I put more in their mouth. Don't call me your king when y'all giving whores the crown. Y'all niggas watered down in me. I'm prohibitionary liquor. I'm like a 9 on the Richter, sublime state of mind, no ordinary nigga.